My name is Dorothy Makusa. We will be starting shortly. We're just waiting for other key people to join. Let's give them about 5 minutes and then we will proceed thereafter. Thank you very much.
Recording in progress.
Ladies and gentlemen, we are starting with the webinar now. We believe the Deputy Minister will be joining us shortly. In the meantime, I would like to recognize formally the presence of our Chief Deputy Commissioner Remand, Mrs. Molepo, who will be making the technical remarks on behalf of the Acting National Commissioner, Mr. Makgoti Tobakgale. And also, ladies and gentlemen, we have got other guests on the platform. I would like to welcome you all protocol observed. It is my privilege indeed to welcome you to this webinar hosted by the Deputy Minister of Correctional Services, Nkosi Phathekile Holomisa. The purpose of being to address the subject of victim-centered parole justice, that is the victim-centered parole proceedings under the theme a victim-centered justice system with the slogan now and not later. So all of us are aware that South Africa is currently plagued by the second pandemic, that which we call the second pandemic, the gender-based violence and femicide. And we are aware that a lot has been done so far by government to address the scourge of gender violence and femicide, but we have not as yet been able to eradicate this type of crime completely. there is still a lot more to be done by government and civil society. So there is a lot in the area of prevention as well as protection of the victims. And we are saying that we are here to talk about that. Now, the Criminal Law and Amendment Act, in terms of the sexual offenses and related matters, seeks to address gender-based violence offenses, those that have been committed against the vulnerable persons, and also provides additional procedures to reduce the secondary victimization of these vulnerable groups. So our focus as DCS is to ensure that perpetrators of these types of crimes against the most vulnerable persons of our society pay their dues as they are serving their sentences imposed by the courts of law. And we also have to make sure and provide opportunity for these vulnerable groups, the victims, to fully participate in the parole processes. So our discussions will be around this. Now, just to share with you in the nutshell before we commence with the details of our program, to share with you those ground rules that are applicable, I am requesting that we all switch off our mics, mute them, and mute also the video so that only the presenters are able to be viewed. And when the time comes for presenters to view, they must switch the video on and switch off after they have presented. We will also not recognize the hands as they would perhaps be raised because we have got the chat box there. Questions and answers, please, you use that icon to state your questions. And also the chat box is there for us to note our matters that we want to raise. So what is also of importance is to note that we will appreciate if you could give us your email, write down your emails as you register so that you can be sent the link to view this recording that will be forwarded to you after this session. I am noting that there is also a comment here. Let me see, on the chat box, there is something that is from the Deputy Minister. He says, I can see and hear the speaker, but I do not know how to participate. Can someone help, please? Colleagues, can you please assist? Because it's very important for us to have the Deputy Minister participating fully as he would wish. Mr. Logan, would you please assist with Motsidisi there? Thank you very much. Okay. We will, in the meantime, firstly, take as part of the program the remarks by Chief Deputy Commissioner Molepo on behalf of the Acting National Commissioner Tobakale. And then secondly, we will have the address by the Deputy Minister. That will be the political overview on this theme. Thereafter, we will take Ms. Francesca Fonse, who will be addressing the questions and answer in the chat box session. And thereafter, we will be taking the closure. So we have only about 3 major items on our program, and we believe that we will be within the timelines that have been set for this webinar. So I would like to check if we have the Deputy Minister. He's there. Thank you very much. Welcome to you, Deputy Minister. We are proceeding Thank you very much, Deputy Minister. We are starting with the part of the program where we have to take the remarks by our Chief Deputy Commissioner, Molepo, on behalf of the Acting National Commissioner. Ma'am Molepo, the floor is yours. We would like you to proceed. I will mute, and then you will be in a position to be viewed on video as well. Over to you, ma'am.
Thank you very much, Program Director, Deputy Minister, Honorable Nkosi Patekile Holomisa, Dilizintaba, esteemed guests, ladies and gentlemen, good afternoon. As already introduced by the Program Director, my name is Anna Molepo. I am CDC Chief Deputy Commissioner, Remand, Detention, and also acting CDC Community Corrections. I am currently representing our current acting National Commissioner, Mr. Mahoti Tubahali. Program Director, the Republic of South Africa is currently experiencing a scourge of domestic violence, femicide, brutal sexual and aggressive offenses committed against vulnerable groups, which resulted in an outcry by the public for the government to meet harsher sentences to perpetrators of such offenses. This has prompted the department to consider the possible review of the parole policy with a purpose of tightening the consideration process in respect of offenders sentenced for aggressive and sexual crimes against vulnerable groups. In terms of legislation, all sentenced offenders are eligible to be considered for parole placement after serving the stipulated minimum detention periods in line with Section 73(6) of the Correctional Services Act 111 of 1998. However, parole consideration does not imply an automatic placement. There are a number of factors which the parole board consider to determine the readiness of an offender for parole, which also includes offenders' aptitude, development, and response to rehabilitation interventions, amongst others. Parole is an international mechanism which is used for conditional placement of offenders under the supervision of community corrections. There are principles which have to be considered by the parole board in ensuring that communities are safe. Some of those principles include the protection of the community, that is, the release of the offender should not affect the community negatively. Protection of the community should be prioritized by means of reducing the risk of reoffending. Consideration should be taken also for any risk of placement to be acceptable and manageable once placed into the system of community corrections. Supervised placement increases the likelihood of successful reintegration, and it also contributes to the protection of the community. Other conditions should also be appropriate and proportional to facilitate the protection of the community and should also promote social reintegration. A program director, provision for involvement of victims in parole board hearings. It was made in both Section 75 of the Correctional Services Act 111 of 1998, which came into operation on 1st October 2004, and Section 2999A of the Criminal Procedure Act 1977, as well as Criminal Matters Amendment Act 2021. If the victim is a child or vulnerable person, and if facilities exist, the representation may be presented by means of video arrangement. A child or vulnerable victim may be accompanied by a family member to provide support and will be allowed to make an input on behalf of the victim during the parole hearing. In terms of contacting victims, program director, the department has appointed auxiliary social workers who assist with the tracing of victims with much focus on the sensitivity of approaching the victims of crime. Contact with the victims is done with due regard to the sensitivity of the matter. Victims are dealt with compassionately, with dearness, gender sensitivity, and with utmost respect. Prevention of secondary victimization of the victim is encouraged with consideration of the circumstances during contact, such as age and their disability needs. Victims are provided with pamphlets on victim participation in parole board in a language they understand, and or pamphlet must be explained to the victims. And the other thing again is that victims are allowed to use a language that they are most comfortable with. The right of the victim to choose not to participate in parole board session is always respected, program director, because we need to ensure that we respect the victim's rights. The contact with victims may invoke trauma, and as such, it is important to ask a victim whether he or she will need counseling as a result of the visit. If so, the victim is then referred to or is advised to contact the non-governmental organizations and external service providers who might be able to assist the victim and the family at the time suitable for the family. The department is also sensitive and mindful to the fact that during sentencing, the victim or relatives, rightfully so, may not have the desire to meet with an offender, either than justice being adequately served. However, program director, the DCS would like to make a humble call to encourage victims of crime or relatives to register their interests with the head of correctional centers near them, to enter into a victim offender mediation or victim offender dialogue, as well as involvement in correctional supervision and parole board meetings when an offender is due for consideration, as and when they have a need to do so. This is a message, program director, that the department communicates during its meetings with communities and during imbizos where leaflets and brochures on parole and victim participation in DCS are distributed. Thank you very much, program director.
Thank you very much, CDC. We appreciate that background that you have given in respect of what the department is doing. That lays the foundation for us to invite the Deputy Minister to deliver the keynote address that is giving the political overview on the theme itself. Deputy Minister, it is my privilege to give you the platform to address us. Over to you. Thank you very much.
Thank you very much, Program Director. Distinguished guests, ladies and gentlemen, August is Women's Month, and together we pay tribute to the many remarkable women of our land. South Africa's constitution, together with its enforcement pieces of legislation, is recognized as one of the most gender-sensitive laws in the world. However, a number of religious, societal, and cultural practices severely impact on the rights of women. Women's Month is about putting a spotlight on the challenges that women still face, as well as celebrating the successes of women in all spheres of life. South Africa forms part of the Global Generation Equality Campaign, which pursues intergenerational partnerships to eliminate gender inequality. South Africa chaired the Bureau for the 66th and 67th sessions of the Commission on the Status of Women in March 2022. The Bureau of the Commission plays a crucial role in facilitating the preparations for the successful outcomes of the annual sessions of the Commission. South Africa will use its membership and participation in this commission to champion the acceleration of gender equality following the 5th Beijing +25 review in 2020, which revealed that despite some progress, real change has been slow and no country can claim to have achieved gender equality almost 26 years after the adoption of the Beijing Declaration and Platform of Action in 1995. As a nation, we must all take concrete action to ensure safer families and safer communities. We must move beyond shock and horror every time a woman or child is raped or killed. We can no longer turn a blind eye to the cries of help from the most vulnerable in our midst. The culture of bystanderism must stop. We must report all cases of assault, abuse, and harassment. We must not normalize the harassment of women. It is the responsibility of all South Africans to end the culture of silence around gender-based violence and to report perpetrators to the police and all those in positions of authority, including traditional leaders, especially in the rural communities. All of us, whether in our communities or in our homes, must do all we can to promote and protect the rights of women and children. The National Strategic Plan on Gender-Based Violence and Femicide requires all of civil society to pull together in order to realize the plan. Together, we can fight women abuse. As Deputy Minister of Justice and Correctional Services, it is my special honor to participate in this very important webinar on the Criminal and Related Matters Amendment Act, Victim-Centered Parole Justice System, now and not later. As part of the rollout of the National Strategic Plan on Gender-Based Violence and Femicide, the Department of Correctional Services is implementing a policy framework which is aligned to the National Strategic Plan Action Plan and related intervention pillars. With regard to victim-centered parole proceedings, Pillar 4 of the NSF, which comprises response, care, support, and healing, is key. DCS is providing this through rehabilitation programs, victim offender mediation, and victim offender dialogues. The outcome of this is victim-centered, survivor-focused, accessible, unbiased, and quality services, which are readily available across all respective levels, across the criminal justice, health, education, and social support systems. Key interventions include, among others, early identification and response, as well as care and support services by the state and civil society, which must be victim-centered, survivor-focused, and trauma-informed. This will strengthen the recovery and healing of victims and survivors, as well as result in the reinforcement of a victim-centric parole regime for GBVF-related offenses. To this end, DCS is implementing the following approved policies. 1, policy framework addressing gender-based violence in line with the National Plan on Gender-Based Violence and Femicide. 2, emergency response plan on gender-based violence and femicide in South Africa. 3, policy and framework to manage sexual violence, abuse of inmates. 4thly, restorative justice policy. 5, DCS victim offender mediation. 6, DCS partnership with the Foundation of Victims of Crime, an NGO which assists with the tracing of victims. Complainant victim involvement policy in correctional supervision and parole boards, promoting the Victims Charter. and standard operating procedures for the management of lesbians, gay, bisexual, transgender, intersex, and queer plus. Key activities include an integrated service delivery model drawing on existing good practices that strengthens relationships and referrals within DCS. Having mechanisms in place to enable correctional facilities to respond to the basic needs of GBVF victims and perpetrators. Support programs for victims and survivors of workplace GBVF and integrating it into the employee wellness programs. Victim offender mediation, victim offender dialogue programs, and victim representation, especially during parole considerations. Ensuring that all GBVF-related policies have clearly articulated referral mechanisms for the victims. And lastly, amendment of the Correctional Services Act 111 of 1998 to cater for a review of the parole system. The VODs are a platform for a dialogue between the offender and the victims of the crime, whilst VOMs, victim offender mediations, provide a platform for a conversation between the offender and the communities whose members were offended by the offender's acts of criminality. The idea is to allow the victims or the community to get an understanding of what was going on in the mind of the offender when they committed the crimes that resulted in the suffering of the victim and the community. Participation is always victim-centered and is voluntary. After successful private face-to-face VOD, VOM activities, the process of public victim offender dialogue testimony by offenders and victims follows. Victims are informed of their right to participate during consideration process. Victims are further afforded the opportunity to make representations during consideration of offenders for placement or release. The VOD and VOM processes are facilitated for willing parties to ensure that relations are restored and harnessed. DCS regional offices coordinate community assemblies called Izimbizo and stakeholders' participation, including involvement of ex-offenders and victims. 16,996 victims participated in the VOD and VOM processes during the last financial year, starting in April 2021 and ending on 31 March 2022. It should be noted, Program Director, that the total number of victims who participated in the processes does not only reflect victims of sexual offenses, but includes other types of crimes, including aggressive, economical, and drug-related crimes. To ensure the successful reintegration of offenders into communities, parole considerations for serious offenses listed in Section 299A of the Criminal Procedure Act 59 of 1977, read with Section 75, subsection 4 of Correctional Services Act 111 of 1998, should include victim participation to provide a platform for dialogue between offenders and victims and thereby contribute to healing and restoration. Victims of crime are invited to writing per letter at least 30 days in advance, indicating the date, venue, time, and the choice to attend. There has been an increase in the number of victims who participated in correctional supervision and parole board proceedings during the last financial year as compared to the previous financial year of 2020-2021. Rates of violence, in particular, domestic violence, have dramatically escalated around the world. It is clear that the GBV pandemic has exacerbated risk factors and laid bare the shortcomings of previous efforts to prevent and respond to this shocking emergence. South Africa needed much more than just speeches, symposiums, and other forms of engagement, and enacted the Criminal and Related Matters Amendment Act so that our criminal justice system could be more effective. This act seeks to offer protection to the victims of abuse and makes it more difficult for perpetrators to escape justice. Furthermore, it responds directly to our ideals where the victims must be at the center of the criminal justice system. We have listened to many voices as people have been complaining about laws that seem to give more protection to the protectors, rather the perpetrators, rather than the victims. Our parole hearings demand that the victim must be given a voice, either in person or in writing. Parole conditions for those who are eventually placed out cannot escape the responsibility of protecting the victims. There is a need to build a mechanism wherein we are able to prevent abuse from occurring in the first place. It has to start at a tender age, where boys are taught values and behavior that will mold them to respect and protect women. TCS is at the receiving end of the criminal justice system and is therefore obliged to respond to the call of the nation by tightening parole policies and providing rehabilitation programs to inmates, probationers, and parolees, as well as restorative justice to heal the wounds caused by GBVF. Hence, our efforts to enhance social cohesion. We cannot afford to be seen as adding salt to the gaping wounds of the victims of crime by adopting policies and practices that are not sensitive to their pain and suffering when pushing ahead with social reintegration programs. Ladies and gentlemen, as the citizens of this country, we must show zero tolerance to any form of violence or discrimination against women and girls. In this regard, I urge all concerned structures to take full advantage of the legislative and policy frameworks put in place by government to empower and protect women. We are all aware that there is an enormous amount of work to be done to eradicate the scourge of GBVF. You also know that we will only achieve this by working together. Let us all therefore join hands to make South Africa a safer and freer country, not only for our women and girls, but for all citizens. It is critical that government services for survivors are regarded as essential and remain open with adequate resources and measures in place to support health and social services to care for survivors of violence. It is time to break the cycle of GBVF. Finally, as the President Ramaphosa has said, just as gender-based violence is all of society's problem, it is all of society's responsibility to bring it to a decisive end. We have made a start, but as the terrible crimes in Krugersdorp remind us, we need to do much more, and we need to act with greater urgency and purpose. I thank you, Program Director.
Thank you very much, Deputy Minister. We believe that we have heard the message, and we really would like to see things changing for the better. Allow me, Deputy Minister, to give the platform to Mrs. Francesca Fonse to take the question and answers session, those that have been posted on the chat box as well, so that we can have this kind of interaction with other participants on the platform. Mrs. Francesca, you are welcome to start. Thank you very much.
Thank you very much, Program Director, for giving me this opportunity. There aren't many questions in the chat box in the Q&A, so I want to start by a statement. We as a society normalize macho behavior through our attitudes and our conscription to macho behavior, violent behavior, and victim blaming, and all forms of expression. That said, the 3 GBV Amendment Acts make provision for a more victim-centered approach, that would hopefully change this, where victims are too scared to really optimize the power that is within our acts, to assess them, to heal, and also to have access to the accountability that should be afforded for their trouble. I want to then look at Section 42 of the Sexual Offences Act, which state that it's the obligation of the Minister for Justice and Correctional Services, now there's two ministers, to establish and maintain the NRSO, the National Register for Sexual Offences, designate a fit and proper person with due regard to his or her experience, conscientiousness, and integrity as the registrar of the NRSO. It further provides that the registrar must exercise and perform his or her powers, duties, and functions subject to the provisions of Chapter 6 of the Act and regulations. So now, from a perspective of a victim, and we're dealing with sexual offenses on the one hand, in other words, in the event of a rape, assault with grievous bodily harm, anything that has got to do with a sexual offense. So there's your parolee that would be in that framework. And then we would also have a parolee that would fall into the framework where a woman was actually killed. In other words, it would be a femicide. So there's already two differentiations when it comes to bail and paroling. Now, when we read the Act, it is the Minister of Justice, the Minister of Correctional Services, and now a registrar of the NRSO. My question would be to the Honourable Deputy Minister, how can we ensure, and also, you know, I would also like to hear from the Office of the National Commissioner, how can we ensure that there is congruent accountability when already in the Act we have 3 different people working towards accountability? That's number one. That is my main question. And then I would like to also, and this is specifically to the Office of the National Commissioner, want to know what would happen to ensure that a parolee will have no access to firearms, and that is there in terms of this new legislation for the people that are going to watch this recording later. Where does it make provision? And does it make provision for parolees to receive post-parole counseling so that we do not have repeat offenders? Thank you. Madam Chair, my first question was directed at the Honourable Deputy Minister.
Thank you very much. Deputy Minister, if you may please respond to that question. Thank you very much.
Well, I shall try, Program Director, but I need to make a disclaimer that these bills, essentially, these 3 acts now, that are meant to address the scourge of gender-based violence, are administered more by the Department of Justice and Constitutional Development through the prosecuting authorities, as well as the courts of our land. But nonetheless, we work together. The minister is one, hence he's called the Minister of Justice and Correctional Services. I think the intention is to ensure that these provisions are implemented effectively and properly by having to ensure that the minister is involved, the registrar of the registrar of that national register for sexual offenders, to ensure that there's political accountability on the part of the ministry, and there's administrative accountability on the part of the registrar to ensure that there are no loopholes that may be used easily by the offenders to avoid being registered and accountable for their deeds, even after they have completed their sentences. But I imagine that the question being directed at me specifically does not exclude anyone else on the platform, including Mama Molepo and Dr. Mosoma, to add more clarity on what I've just tried to explain. Thank you.
Thank you very much, Deputy Minister. I am not very sure if the two colleagues, the Memo Lepo and Dr. Mosoma, would like to say anything, but we will give the opportunity then to CDC Molepo to make her comment or respond. Thank you very much, CDC.
Thank you very much for the questions. Am I audible?
You are loud and
You
clear.
are, ma'am.
Oh, thank you very much. Thank you very much for the questions. In terms of the question of Parole receiving the firearm, what I can start with is that when offenders get sentenced within our facilities, they do go through the admission process whereby we develop a sentence plan. And in that correctional sentence plan, we identify all the programs that the offender has to attend to. So that will be the rehabilitation programs that are relevant to the offender. So as soon as the offender attended all the programs and he or she has reached that minimum detention period and he is due for parole, then he will go through the parole process and he will be released to the community. So prior release, the offender will have conditions for parole. So in the conditions for parole, the parole board will consider the sentence that the offender committed and also the rehabilitation programs that he went through, so that when he is in the community, we need to ensure that there is that community safety whereby offender would have attended, would have gone through all our rehabilitation programs. So within the community corrections space, then that parole, they will be monitored and supervised to ensure that they comply with those conditions that are set in the parole conditions. And within that, when they are being monitored, in terms of the firearms, as the question is saying, whether are they allowed to have firearms, they are not allowed to have the firearms because they will be monitored. They are monitored by our parolees to ensure that they comply with the parole conditions. And in terms of counseling, we also have social workers that will be continuing with the parolees to ensure that our parolees are still being offered or are still being counseled even when they are outside. They are serving their remaining sentences in the community. So we will still continue providing counseling services to those parolees. Thank you very much, Program Director.
Thank you very much, Mem Lepo. May I kindly remind the participants on the platform to just write down their questions on the chat box or on the icon provided, so that they can be taken from that. Thank you very much. You may continue.
Thank you. I have a question here from Ms. Nkosana Ngozo. Her question is, my question is, how will the Department of Correctional Services ensure that proper intervention, that is support and care, is done to the victims before the department call victims for parole proceedings and prevent secondary trauma on the victims? This, to me, is a very valid question, because I deal with traumatized women every day, and many women are so traumatized through violent happenings, you know, domestic violence and gender-based violence within their surroundings or within their relationship, that just going to court and facing that person that has not been convicted to court is already traumatizing. That is why the Act now make provision for several tiers of assistance for victims of violence. So this is a very pertinent question, because what I've realized is a woman goes through a judicial process. It is very traumatic. Then she does not deal with this person for a while. But every time she is confronted to deal with the perpetrator, whether it is sexual violence or physical violence or even emotional violence, every time she's called upon again to face that perpetrator, it triggers her and it really opens up a lot of trauma. So therefore, in this country, not only must we look at the trauma of the victim at the proceedings, but during parole proceedings, which might now be an extended period, we need to then protect them too. So, Ms. Anna Molepo, how will the department prevent secondary trauma in their preparation of victims when they have to partake in parole proceedings? Thank you.
Over to you, Sirisi Molepo. You may respond.
Okay, thank you very much for the question. In terms of the interventions or the support and care that is being provided to the victims, as a department, as I have indicated earlier on, we do have social auxiliary workers that starts with the process of counseling. They do counsel our victims prior victims appearing in parole. So we do have that pre-counseling that commences even before parole, and even after parole hearings. The social auxiliary workers and also social workers within the department, they do continue providing services to our victims based on their needs that have been identified prior to the parole hearing. So there will be that process that goes on pre-counseling, that is before attending the VODs, before attending the parole hearing, and even after those sessions, they would still continue providing the services as per their needs that have been identified. They will also be referred for further counseling in communities to other stakeholders. So during identification, during that pre or before attending the parole hearing and also the VODs, there will be those needs that have been identified, and the social auxiliary workers will ensure that if, for example, the victim needs to be referred to other services like social development or South African Social Security Agency or the Department of Home Affairs, then the social auxiliary workers and our social workers will ensure that they do assist the victims in that area. So they ensure that they interview the victims, they offer counseling, and where we do not offer the services, they will ensure that they refer the victim to relevant service providers. Thank you very much.
Thank you, Ms. Molepo. I would like to raise another issue with you, particularly, if you please. And that pertains specifically towards parole boards. I would personally like to know, and I'm sure any woman watching this at a later stage would like to understand, what are the considerations of the parole board? And how do they deal with factors like incest? A parolee committed the offense within his family, his child, a stepchild. Should the parolee still be married to the mother? What supervision would be applicable in such a case, and what support services to that victim would be applicable if there is maybe a situation where the people want to work through this trouble experience? And then, do we look at the age of the victim? Because a victim that in a sexual offense that was young is now grown up, and now that victim revisits. Do we look at the change in the circumstances? Age brings different triggers at different ages. And how do you think the parole board should look into the psyche of this parolee, or probable parolee? Do they undergo an evaluation before they come up for parole, so that the probability of them repeating an offense can be assessed? Can you please give us some insight into those things? Thank you.
Ma'am Molepo, will you kindly respond to that one?
Can you hear me? Can you hear me?
Can you hear
We can hear
ma'am?
you, ma'am.
Okay. Thank you very much for the question. In terms of the considerations, the first one is in terms of the legislation. For parole considerations, the first one, as indicated earlier, is in terms of the considerations to say, did the offender completed the minimum detention period? So that is the first issue in terms of legislation that parole will consider. And the second issue will be in terms of the programs that the offender has attended during his or her sentence. That is all the rehabilitation programs depending on his correctional sentence plan that I've already indicated that during admission, the offender will be assessed in terms of his needs, and we develop the correctional sentence plan that identifies all his needs, all his development needs, and also rehabilitation programs that the offender must attend. Let me make an example to say, let's say the offender committed murder, for example, then the offender will be subjected to anger management program. So that will be some of those programs that will be indicated in the offender's correctional sentence plan. So as soon as the offender has attended those programs, both rehabilitation and also development programs, so that he can also acquire some of the skills that he will be able to utilize when he gets out of our system, to ensure that he is employable when he gets outside, and also his attitude. So the parole board will consider those programs, whether the offender attended those programs. And the other thing is in terms of supervision, what you have indicated to say what supervision would be applicable, to say after the offender has attended those programs, when he gets out, there will be supervision that must be considered. And even when he's in community corrections, he would still go through those programs to ensure that prior reaching his sentence expiry date, he would have attended all the programs. So the other question is with regards to the psyche, to say we do have social workers in our system. We also have psychologists within our system. So prior release on parole, the psychologist would have also assessed the parolee, and he or the psychologist will write a report, a psychological report, and provide it to the parole board, so that the psychological report will also be taken into consideration. So the parole board will go through the psychological report, and if they are happy, they will then consider the offender for parole. So it will be, the offender will be identified, will be assessed by social workers and psychologists, even to identify those risks and the probability of reoffending prior being released. And if the offender, if maybe based on the psychological assessment, then there is the risk that has been identified, the psychologist will refer for further psychiatric intervention for that offender. So those are some of the programs that offenders will have to go through prior being released. I think the other question is in terms of the age, to say we do consider the age as indicated, that the social auxiliary workers will interview the victim, and if the victim is still underage, the victim will be represented by the family members to ensure that the child is being protected, and the family will decide whether they are ready to take back the parolee into their family. So it will be through those sessions or interventions that the auxiliary social workers will involve the family prior being released, and even after release, there will still be that continuation to ensure that if the family has problems with the parolee, then it will be reported even to the monitoring officials. Thank you very much, Program Director.
Thank you, Ms. Molepo. We have a question here in the Q&A for the Honourable Deputy Minister, and it comes from Colin. And Colin says, my question relates to how, or do you relate to the inspecting judge office with regards to complaints from the offender who is eligible for parole with key challenges, namely 1, victims is no longer traceable for the dialogue initiation, and 2, long-term sentenced inmates are eligible for parole struggling with sentence remarks required by the parole board. This delays the process and sometimes being beyond the capacity of the parole board. So this is very much a question centered on the parolee. So 1, what happens when the victims are no longer traceable, and 2, when the parolee is struggling with sentence remarks required and there's many delays. We will get to all your questions, both in the chat and in the Q&A. Let's give the Deputy Minister a chance to answer that question, please. Thank you.
Thank you very much once again for the question. Now, it's very important and essential that the victim of crime is given an opportunity to express her views before a final determination is done, when consideration for parole release is done. So a thorough and vigorous search for the victim is conducted by the people that have been mentioned by Ms. Molepo, to ensure that we leave no stone unturned. However, where it is not possible to find the victim, then the parole board, with all the information at its disposal, has a discretion, in my understanding, to determine whether, in spite of the unavailability of the victim, then the parolee, the offender can be released. Because at the end of the day, we have to look at the interest of the parolee, the offender as well, when the offender has undergone properly and meaningfully all the rehabilitation programs that have been offered to them. So if it is not possible then to find the offender, the victim, as I say, the law allows that the person be released. Regarding we work very closely as a department with the inspecting judge heading the Judicial Inspectorate for Correctional Services, that is JICS. There's a lot of cooperation. Sometimes, of course, there will be a bit of a tension between the officials who are supervised by whose work is overseen by the JICS. But nonetheless, in general, there's a great deal of cooperation, because that assists the department also in making sure that it complies with all the prescripts of the law and international treaties. Regarding the remarks, that does tend to be a challenge in a number of instances where the judge's remarks at the time of the sentencing of an offender, we find that they are not readily available. But in general, there's a lot of cooperation between the police, between the prosecuting authorities, and also the judges. There are regular meetings that are held with our officials in order to make sure that there is a seamless way of operation, so that one section in the justice administration system does not affect negatively the other section. Because if you don't have all the information that is required, if, for instance, the police don't provide the requisite information to the prosecutor, or the prosecutor does not prepare properly for the court, or the court doesn't apply its man properly, then you might end up in a situation where either the perpetrators of crime escape the system, or people who are not supposed to have been convicted and or sentenced, you find that they get sentenced. So there's a need for a cooperative way of working between all of these sectors in the justice administration section. Thank you.
Thank you, Honourable Deputy Minister. I'm going to go into the chat, and this will be directed at Ms. Molepo. Ms. Molepo, Pride said in the chat, social auxiliary workers are only supposed to render services under the supervision of a social worker as per the SSP ethics. They are not well equipped to deal with cases they come across in the DCS, in my opinion. It is really unfair to use them since they do not have the extensive training. And then there was another anonymous person that also asked, what considerations are made when removing an ex-sexual offender off the NRSO and the National Child Protection Register? So Ms. Molepo, let me give you a chance to answer those two. Then we will go back to the Q&A. Thank you.
Thank you. Is it okay? Thank you very much for the questions. In terms of the first question regarding the social auxiliary workers, yes, the social auxiliary workers, they are not yet qualified social workers. So they do provide the service under the supervision of social workers. So they do have supervisors, social work supervisors, who are guiding them and also supervising them to ensure that they do provide the service. So it is true that they are not yet qualified and they are under the supervision of the qualified social workers. Hence, we have appointed them to assist us in tracing the victims so that when it comes to counseling, social workers will be there even to assist. So social auxiliary workers, they do assist us in terms of tracing the victims. So that is our response. We do agree, social auxiliary workers, they are appointed to trace the social worker, the victims. The second question, I think I've missed the second question, Francisca.
Ms. Malope, what considerations are made when removing an ex-sexual offender off the NRSO and the National Child Protection Register? I know the periods have been extended, so could you please explain those to us? Thank you.
Thank you very much for the question. But with regards to the sexual registers, as the department, we do not have those registers. I think they are being handled by the Department of Justice. So as the department, in terms of the registers, we do not handle those registers. Thank you very much.
Thank you for that question. I can attest to the fact that there is a whole process to which an offender or an ex-offender can apply to be taken off these registers. However, where the certain periods regarding certain offences, for instance, in some it was 12 years, it's now 20 years, and where it was 6 years, it's now 12 years. So there's an extension, but there is a due process to follow. It's not easy, and it should never be easy. So I hope that answers that question. Okay. I'm going to go back to the Q&A, and there's a question that's addressed to me, and it says, I am a 55-year-old woman who was attacked on Women's Month by a so-called boyfriend of my late daughter in 2020 during lockdown after curfew, and the man was drunk. So we have a lady here, her daughter is deceased, and in 2020 during lockdown, after curfew, the man was drunk and he attacked the mother. I want to take action about it because it haunts me every time that I think about it, more especially because it ended up with my daughter being dead. In other words, she's deceased. I wish to have some advice on where can I start with this again. And there is again evidence that this man once assaulted my daughter, who succumbed from her injuries, which he started. So he perpetrated the violence against the deceased daughter while she was pregnant, and continued when the baby was born. Where do I start? Ma'am, you start by going and opening a case, and then you involve with SAPS. They need to give you a case number. They need to involve a social worker, and SAPS needs to investigate. It is the onus is upon them to investigate this. This man is obviously has got repeat habits that indicates, and in the case of your daughter's passing, there must be evidence somewhere on record, also with Department of Health, of her injuries and the reason that she succumbed. So please go to SAPS, open a case, get them as much information as you can, make an extensive subpoena with regards to what happened, what transpired, and SAPS must subpoena this man to come in, and you can give your best affidavit with regards to what's transpired. Where did she succumb? Was she in hospital when she passed away? All those records can be subpoenaed and accessed by SAPS, and they can build a case. And if this gentleman is indeed guilty, they should bring him to task. I hope that helps you. I will also post my phone number in the chat, and you can contact me once you have initiated your process. Then we have a question from General Nsiki Memela Ntumi, and he asked, or she asked, has research been conducted to confirm that victims of GBVF are indeed not subjected to secondary trauma during these dialogues? I would assume it would be these interactions with the parole board prior to deciding whether a parolee should be paroled. A lot of the legislation has just been amended. So Ms. Molepo, I don't know if you have an answer, but I know there is a lot of research that is current and in process. So we won't have a clear answer there, but Ms. Molepo, if you can answer that, is there any research?
Thank you very much, Francisca, for the question or for the comment. Yes, currently we do not have an answer, especially in terms of research, to say, do we have a research in that area? So we do not have a direct answer for now in terms of the research that have been conducted relating to secondary victimization of our victims. So we do not have research that have been conducted. Thank you very much.
Thank you, ma'am. And I can concur. I think we are treading into new ways of conduct. We are treading into new aspects of acts, a new victim-centered mindset in courts, in parole, and with the amendments of all three acts. And therefore, I think a lot of our research is only really, gaining a momentum at this stage. and we will probably in due course be able to answer how
Hello, colleagues, ladies and gentlemen. I think there is some kind of freezing on the side of Mrs. Fonse. I do not know if my other colleague, Mr. Dikweni, are you able to assist in the meantime? Mr. Dikweni? Are you still around, Mr. Dikweni?
No, Mr. Dikweni has stepped off a bit.
Okay, thank you very much. I think she is back now, Mrs. Fonse. The floor is yours. May you please continue? You were still phrasing the question for Memolepo. Please unmute, Mrs. Fonse.
apologies.
You
Apologies to the
welcome.
meeting. This is not my doing. This is ESCOM. We've already had our load shedding, but this seems to be a general power outage in my area. So what we are looking at is, you know, what I was trying to phrase is that currently the research is going to escalate because we have a new paradigm with regards to the 3 amendments to the GBV Acts. So obviously, we can't answer the question with regards to what research and what conclusions have been reached with effectively lessening the trauma for victims, families, whether it is in court proceedings, whether it is at parole hearings. We cannot conclusively answer that at this stage. However, I would like to ask Ms. Malepo, from your understanding, ma'am, how would we address going forward? How would we incorporate all these measures? And there's quite a concern with regards to the auxiliary social workers, and you did answer it, and we do understand that these workers are working under supervision. But I would like to ask you, what is your vision for the Department of
Our apologies, ladies and gentlemen. I think with the power outage, we are bound to have challenges such as this, the one that is being experienced by Mefonse. I am just requesting that we give her just one moment. I think she will be with us now. Memu TDC, are you able to assist her better?
I see she's back. If she could just unmute.
Okay, so that is what I want to, and I'm going to speak fast now because I'm scared I'm bombing out again. Ms. Molepo, Can you tell us, in terms of the new construct that we're trying to create, the new way that we want to move forward, and the complexities of human behaviors, what do you see? What is your vision for the Department of Correctional Services? How do you see to apply this amendments of the Act going forward? And how will you assist with the deploying of more social workers? Will you involve the Department of Social Development? There are many social workers in South Africa that's currently not employed. And I want to know, how can we see these people deployed? How can they be incorporated so that we can have more efficient supervision of parolees, please?
Ma'am Molepo, may you kindly respond to that one?
Thank you very much, Ms. Fons, for the question. The first one, in terms of the social auxiliary workers, we are currently, as the department, reviewing our structure to ensure that we have the right people. We also have the right number of social workers that will be able to assist in terms of rehabilitating our offenders. So with regards to reviewing our structure, we are also working together with the Department of Social Development in terms of appointing social workers. So the number of social workers will be increased to ensure that our offenders will receive rehabilitation programs. And the other thing, as a department, we are saying that corrections is a societal responsibility. So what we are doing as the department, we are collaborating with other stakeholders to ensure that we work together with the NGOs, non-profit organizations. We sign the Memorandum of Understanding and also Memorandum of Agreements. We are participating in Community Corrections Forum and also Community Policing Forums. We work together with the JCPS cluster departments to ensure that even the communities are involved in our services that we provide. So we are saying that corrections is a societal responsibility. Hence, we ensure that we collaborate with stakeholders. In all the regions, we do have various stakeholders that we are working with. So those stakeholders will be assisting us in terms of rehabilitating our offenders, even in terms of monitoring parolees and probationers outside there. They will be assisting us. So what is critical is that corrections is a societal responsibility, and we need to get communities, families, and everyone out there to come and join hands with us, and we work together to ensure that our communities are safe. Thank you very much, Ms. Fonson.
Thank you, Ms. Malope. That is really ensuring. I would going to ask to please furnish my phone number to the lady that has asked the question in the chat so that we can support her going forward in her process. And with that, I'm going to conclude as National Champion for Women of South Africa. And I'm going to say to any woman who looks at this recording at a later stage, you are not alone. There are many support structures that are currently viable in this country. There are many avenues that is being investigated within the Department of Justice and all the first responder departments, including correctional services and the SAPS, to assist you and to be more sensitive towards you going forward. You are always welcome to contact me and my association, WIN, W-I-I-N, Women Integral Impact Network, and we are women who support other women going through the traumas that most of us have already overcome. With that, I would like to hand back to our facilitator, Ms. Dorothy Makuza. I do not see any further questions. I think our questions have been extensively answered, and I want to once again apologize for bombing out a little bit, but it's circumstances beyond my control. And I wish everybody a most incredible Women's Month and Women's Day on Tuesday. And I want to say thank you to our Honourable Deputy Minister for answering us so effectively. And I want to say thank you to each and every person that assisted in this great session today. And that is me bowing out and handing over to you, Dorothy. Thank you.
Thank you very much, Mrs. Fonse, for being part of this webinar and for so eloquently taking the questions, some of them yourself, and also assisting us in taking the questions and answers from the chat box. Deputy Minister, we have come to the end of the program, and I would like to take this opportunity to thank you for having hosted this session, and I believe all the participants have gained a lot, and the homework that is with all of us is that it is now and not later that we should start implementing the laws and playing our part as the Department of Correctional Services. Thank you very much for this opportunity. Thank you very much, one and all, for participating. And I would like to declare this webinar closed. Thank you very much, Mutsidisi, for your assistance. The session is adjourned. Thank you.
Thank you.